So we are pulling from the most highly trusted foundational polity materials to master how this country actually functions when you peel back that top layer.
It is a critical subject because to truly grasp it, you have to completely shift your paradigm. Like when most people study the governance of a massive country, they hyper-focus on vertical relations.
Right, the center versus the state.
Exactly. The union government at the very top, pulling the levers, and the state governments reacting at the bottom. But you can't run a union of diverse states with just top-down commands. The real magic and really the real friction, it happens horizontally.
Horizontally. So we are looking strictly at how the states deal with one another.
Precisely. Because when two states share a border or a river or an integrated economy, how do they interact without the whole system just grinding to an absolute halt?
Yeah, it's that state-to-state dynamic. And to understand this, we aren't just going to list off a bunch of articles for you to memorize. We need to look at the actual problems of running a massive nation and the tools the framers built to solve those problems.
That's the best way to retain it for the exams, too.
For sure. So let's start with the most explosive horizontal issue you can possibly have. Forget paperwork for a second. Let's talk about survival. Let's talk about water.
Oh, yeah. Water is the ultimate stress test of horizontal relations.
Because when a massive river flows through 3 different states and everyone needs it for their farmers, who gets to turn on the tap?
Oh, land is easy, right? You draw a line on a map, you build a fence, and you have a border, but you cannot tell a river to stop flowing at that fence.
No, you can't.
A state upstream can dam a river, completely starving the state downstream. That immediately brings us to Article 262, which provides for the adjudication of disputes over interstate river waters.
Okay, hold on, because I need to challenge this right out of the gate. When you read the actual text of Article 262, it says Parliament may, by law, provide for the adjudication of these disputes.
Right.
But then it drops this massive bombshell. It says Parliament can explicitly bar the Supreme Court of India from having any jurisdiction over these water disputes.
It does.
Wait, why? Why on earth would the Constitution deliberately bypass the highest court in the land for something this important? If 2 states are fighting over a lifeline, shouldn't the Chief Justice be the one deciding?
It sounds totally counterintuitive until you look at the reality of how courts actually work. The framers realized that water disputes are not standard legal battles.
How so?
You aren't just reading a breached contract. These are highly technical, deeply emotional, and economically volatile issues. They require an understanding of hydrology, seasonal monsoon patterns, soil salinity, and the livelihoods of millions of farmers.
Right, which a normal judge wouldn't necessarily know about.
Exactly. Standard court litigation is built on strict legal frameworks, endless cross-examinations, and decades of appeals. A judge is an expert in law, not river basin management.
That makes sense.
If you put a water dispute in the regular courts, you might not get a decision for 40 years, and by then the crops are dead.
So the idea is to keep a highly technical, really messy fight out of a slow-moving legal system.
Precisely. It requires highly specialized, ad hoc tribunals. So, using the power of Article 262, Parliament enacted the Interstate Water Disputes Act of 1956.
The 1956 Act. Got it.
Yeah, and this allows the center to set up specific, temporary tribunals made up of experts and judges. And here is the crucial mechanism you absolutely must remember for your exams. The award given by these tribunals is final and binding.
Final and binding. So once the tribunal takes up the dispute, the Supreme Court cannot interfere with the adjudication at all.
Correct.
So it's not a suggestion, it's law. Now, if you are analyzing this for an exam, you need to lock in the practical history here. Tribunals have been set up for major, heavily contested rivers, the Krishna, the Godavari, the Kaveri, the Narmada, the Ravi Beas.
All the big ones.
Yeah. But there is a massive historical flaw we have to talk about. You mentioned regular courts take too long. Well, early on, these tribunals were taking forever, too.
They really were.
They would drag on for decades. State planners were completely paralyzed because they didn't know how much water they would have in, 10 years.
And that paralyzed state-level agricultural planning across the board, which is why you have to pay attention to a critical amendment made in 2002 to that original 1956 Act.
Right, the 2002 amendment.
It introduced a strict biological clock for these disputes. Under this amendment, once a state requests a tribunal, the center must set it up within 1 year.
1 year.
And once it's set up, the tribunal must give its final award within 3 years.
1 year to set up, 3 years to decide. That is a massive exam detail. Make sure you write that down.
And just to keep the terminology crystal clear, while we're talking about 1956, Parliament passed another act that same year, The River Boards Act.
Oh, right.
It's vital not to confuse the two.
Yeah.
The River Boards Act sets up advisory boards to help states develop a river valley cooperatively. The Interstate Water Disputes Act sets up tribunals that adjudicate and bind.
So one is for planning, the other is for fighting.
Exactly. Advisory versus binding.
Advisory versus binding. That is the perfect pivot, actually, because states aren't always at each other's throats over water. Sometimes they just need to, align their policies on transport or internal security or health.
Right, the day-to-day stuff.
Exactly. How do they handle routine day-to-day policy alignment without dragging tribunals into the mix? If Article 262 is the boxing ring, what is the conference room?
That conference room is the Interstate Council, established under Article 263.
Article 263.
The Constitution gives the president the power to set up this council if it serves the public interest. Its mandate is really broad. It can inquire into disputes, investigate subjects where multiple states have a common interest, and recommend better coordination of policy.
And it's fascinating because the Constitution always had Article 263, but the government just ignored it for decades. It wasn't actually established until 1990.
Yeah, it took a long time.
And that happened directly because of the famous Sarkaria Commission, which heavily recommended it to smooth out center state and state-state friction.
The Sarkaria Commission is a huge keyword to remember there.
Definitely. Let's look at who is actually in this room. The Prime Minister chairs it. Then you have the chief ministers of every single state and union territory, plus 6 union cabinet ministers.
It's a packed room.
And later on, in 1996, they added a standing committee just to ensure things didn't stall between the big meetings.
Picture that room for a second. You have the Prime Minister, every chief minister, and the most powerful cabinet members. It is arguably the ultimate gathering of executive power in the country.
Right, but this is where I have to push back again. You get all of that incredible power in one single room, and yet the Interstate Council is purely advisory. It can only recommend.
That's true.
What is the actual point of an ultimate gathering of power if it can't enforce a single decision? That sounds like a glorified, toothless debate club.
It's a very fair critique, but you have to look at the psychology of political power here. Think about why it has to be advisory.
Okay, why?
If a council of rival politicians could make binding decisions by a majority vote, what would happen? If 5 states could outvote a 6th state and legally force that state's chief minister to implement a policy they absolutely hated, chief ministers would simply boycott the meetings.
Oh, wow. Yeah, they just wouldn't show up.
Exactly. The entire system would collapse into resentment. The advisory nature is a feature, not a bug. It provides a political safe space.
A safe space.
Yeah. It allows leaders to negotiate, share intelligence on things like cross-border crime, and align their goals without the fear of being legally trapped by a vote.
That makes a lot of sense, actually. The Water Tribunal forces a solution because water can't wait. The council advises because politics requires consensus.
Perfectly stated.
Okay, so we have tribunals for resources and councils for high-level political strategy, but let's bring this down to the ground level. Let's go back to that scenario I mentioned at the very beginning of the deep dive.
The loan default in Maharashtra.
Yeah, exactly. A regular citizen moving between states. How does the administrative machinery handle that without completely breaking down?
That is where Article 261 comes in. It introduces the principle of full faith and credit.
I love the mechanics of this. I actually like to think of Article 261 as the country's shared clipboard.
Shared clipboard.
Yeah, think about your computer's operating system. If you copy a paragraph of text in your web browser, you fully expect to be able to hit paste in your word processor, and the text just appears.
Right.
The applications are totally different, they do different things, but the underlying operating system forces them to honor the same piece of data. Article 261 is India's shared clipboard.
That's a really great analogy.
The Constitution mandates that public acts, which are laws, public records like birth or marriage certificates, and judicial proceedings, are mutually recognized across the entire territory of India.
It is the ultimate administrative glue. If we go back to your opening example, the bank in Maharashtra gets a civil court judgment against the defaulter. When that person flees to Gujarat, the bank doesn't have to hire new lawyers, file a new lawsuit, and prove the debt all over again in a Gujarati court.
Because that would be a nightmare.
An absolute nightmare. Because of full faith and credit, the final civil court judgment delivered in Maharashtra can be directly executed anywhere else in India. The court in Gujarat must honor the judgment as if it were their own.
It prevents a massive, balkanized legal mess. Your paperwork, your rights, and your legal liabilities, they travel with you. It binds the states together at the citizen level.
It really does.
So we've aligned the paperwork and we've aligned the courts. What's next? We have to align the money. And this is a massive piece of the puzzle. We are moving into trade in commerce, which spans Articles 301 through 307.
You cannot have a unified country if you do not have a unified economy. Article 301 lays down the absolute foundational guarantee. Trade, commerce, and intercourse throughout the territory of India shall be free.
Shall be free.
Yes. The overarching objective is to break down state borders when it comes to the economy, creating one single massive national market.
It sounds great in theory.
Yeah.
A farmer should be able to load a truck with spices in Kerala and sell them in Punjab without hitting a dozen internal walls. But for a very long time, that just wasn't the reality, was it?
Not at all. For decades, the spirit of Article 301 was constantly undermined. States were desperate for revenue, so they found loopholes.
Of course they did.
They imposed entry taxes, octroi duties, and all sorts of really complex levies on goods crossing into their territory. Imagine the physical reality of this pre-GST era.
It was chaos.
You would have lines of commercial trucks stretching for miles at state borders. A truck driver might sit idling at the Maharashtra-Karnataka border for 3 days, just filling out forms to pay a 2% tax.
Wow.
It bred corruption, it destroyed perishable goods, and it was a massive drag on the national GDP.
Which is exactly why the introduction of the GST, the goods and services tax, was such a monumental shift for horizontal relations.
Huge shift.
The GST essentially rescued Article 301. By absorbing all those fragmented, cascading state taxes into one unified system, it literally stripped away the physical border checkposts for goods.
It forced the states to actually operate as the one national market the Constitution envisioned.
It was a realization of the original constitutional promise. But of course, no freedom in the Constitution is absolute. There are always carefully calibrated exceptions.
Always.
Right, let's get into the fine print. Articles 302, 303, and 304 dictate the limits on this free trade. Break down how a government can actually restrict this freedom.
It works like a hierarchy. Article 302 gives Parliament the power to impose restrictions on trade between states in the public interest.
So Parliament has the top authority.
Yes. If there is a severe national reason, say, regulating the movement of essential medical supplies or hazardous materials, Parliament can step in. But immediately, Article 303 applies a strict break.
What does 303 do?
It says Parliament cannot discriminate. It cannot make a law that gives preference to one state over another. You cannot decree that trade is free for everyone except for goods coming from Tamil Nadu.
Ah, okay.
The only time Parliament can break that non-discrimination rule is if there is a severe declared scarcity of goods in a specific part of the country.
Okay, so the center has restricted power. What about the states themselves? States are always trying to protect their local industries. Under Article 304, can a state tax goods coming from its neighbors?
Yes, Article 304 allows a state to impose taxes on goods imported from other states, provided they tax their own local goods at the same rate.
So it has to be equal.
Right. They can also impose reasonable restrictions in the public interest. But there is a massive constitutional tripwire here that is a favorite for examiners.
Listen up if you're taking notes.
A state legislature cannot just wake up and pass a bill to restrict trade with a neighboring state. Any such bill requires the prior sanction of the president before it can even be introduced in the state legislature.
Oh, that is the safety valve. The state has to go to the president, which effectively means the union government, and get permission to restrict trade.
Exactly.
It positions the center as a neutral referee to stop states from launching retaliatory mini-trade wars against each other. Now, before we leave the economy, there is a highly testable trivia fact regarding Article 307.
Yes, this is a fun one.
We have this complex web of trade rules, and Article 307 explicitly allows Parliament to appoint an official authority to carry out the purposes of Articles 301 to 304, an actual interstate trade and commerce commission.
And the fascinating reality is, since the Constitution was adopted, Parliament has never created one.
Never.
Never. The power is sitting right there in Article 307, completely unused. We have no dedicated statutory authority managing interstate trade. It's handled purely through regular political and bureaucratic channels.
Lock that away in your mind. Article 307 exists. The authority does not. Now, if you are actively taking notes, I want you to draw a thick, heavy line under everything we just discussed, because we are making a major shift.
A very important shift.
Everything up to this point, water tribunals, the Interstate Council, full faith and credit, trade rules, all of that is constitutional. It's baked into the supreme law of the land.
Right.
But to finish our deep dive, we are looking at the critical non-constitutional machinery, the statutory bonus. We are talking about the zonal councils.
This distinction is crucial. Constitutional versus statutory. Zonal councils are statutory bodies. They were not created by the Constitution. They were brought into existence by an act of Parliament. Specifically, the States Reorganization Act of 1956.
And we have to explain why 1956 was the trigger for this. This wasn't just a random year for administrative housekeeping.
Right.
1956 was a year of intense national anxiety.
Absolutely. The States Reorganization Act was the moment India redrew its internal borders based on linguistic lines.
Right, based on language.
The country was creating states for Telugu speakers, Marathi speakers, Kannada speakers. The framers and the leadership at the time were deeply terrified that organizing states by language would spark fierce regionalism.
They thought it would divide everyone.
They feared these new states would become isolated linguistic islands and eventually tear the Union apart.
So the zonal councils were a direct countermeasure, a way to force these newly linguistic states to sit in a room together. And remember, they are part of a larger geographic region.
Precisely.
The 1956 Act created 5 specific zones: Northern, Central, Eastern, Western, and Southern. But look at the brilliant structural design of who sits at the head of the table.
It is entirely by design. You have all the chief ministers of the states in that zone. But the common chairman for all 5 zonal councils is the Union Home Minister.
Think about that. You have a purely horizontal regional gathering, say the southern states, but you drop the Union Home Minister right at the head of the table.
It changes the dynamic completely.
It provides a heavy central anchor to a regional room. It ensures the Union government always has a finger on the pulse of regional anxieties before they boil over.
And much like the Interstate Council, zonal councils are strictly advisory. Their mandate is to foster cooperation on economic planning, manage linguistic minority issues, coordinate border transport, and ultimately neutralize aggressive regionalism.
Now, there is one major geographical exception you must remember. The 5 zones from 1956 cover most of the country, but they do not include the northeastern states.
Right. They were left out of that original act.
They have a completely separate mechanism. The Northeastern Council was created by its own distinct parliamentary act much later, in 1971. So 5 zones from 1956 plus the Northeast from 1971, all statutory bodies.
We have covered an immense amount of abstract legal and political machinery today. But the best way to ensure this knowledge sticks isn't just to memorize the list. You have to see it functioning together as a living system.
I completely agree. Let's build a narrative sandbox to run all these tools through simultaneously. Let's look at a day in the life of a hypothetical agrotech business operating out of Vijayawada in the state of Andhra Pradesh. We'll call the owner Ram.
Okay, Ram in AP.
Let's watch how Ram's business survives purely because of this invisible machinery.
Let's start with the basics. Water. Ram's massive farms run on water from the Krishna River. If Andhra Pradesh is arguing with Telangana or Karnataka over how much water flows down to Ram's farms, they don't get tied up in a 40-year Supreme Court battle.
No, because of Article 262.
Exactly. Under Article 262, the state relies on a specialized water tribunal whose expert award is final and binding, ensuring Ram eventually gets a predictable water supply.
Meanwhile, Ram needs better highways to transport his crops, and cross-border smuggling is driving up his security costs. His chief minister is tackling these overarching policy issues by sitting down with the prime minister and other state leaders at the Interstate Council under Article 263.
Utilizing that political safe space to negotiate better regional infrastructure funding.
Right. Now, let's say a vendor in neighboring Karnataka breaches a major supply contract with Ram. Ram sues them in an Andhra Pradesh civil court and wins.
And because of Article 261, full faith and credit, Ram doesn't have to start a brand new trial in Karnataka.
Our shared clipboard.
Exactly. The AP court's judgment operates like that shared clipboard. It is honored and executed across state lines, allowing Ram to recover his money.
And when Ram actually ships his final product, let's say it's processed mango pulp, he is sending his trucks all the way up to Punjab. Under Article 301, the Constitution guarantees him a free national market.
And thanks to the GST framework realizing that vision, Ram's trucks aren't stopping at a dozen state borders to pay extortionate entry taxes. They drive straight through.
Finally, Ram, state of Andhra Pradesh, isn't operating in a vacuum. To ensure long-term regional stability, power grids, and economic planning, AP coordinates with its neighbors in the Southern Zonal Council.
That statutory body brings AP, Telangana, Tamil Nadu, Karnataka, Kerala, and Puducherry to the table with the Union Home Minister to ensure the entire Southern Peninsula grows together.
It is genuinely brilliant when you view it as a cohesive system. You have these separate, highly specialized threads, tribunals, councils, shared clipboards, unified markets, all weaving together.
It's an intricate web.
The Constitution doesn't naively pretend that diverse states will always get along. It knows friction is inevitable. It simply builds the invisible machinery to process that friction into progress instead of chaos.
And that is the true hallmark of a resilient democracy. The ability to manage internal conflict through design systems rather than brute force.
So, as we wrap up this deep dive, let's crystallize the golden rules for your exam prep. Number 1, whenever a question mentions interstate relations, immediately shift your brain to horizontal dynamics, state interacting with state.
That's rule number 1.
Number 2, memorize the power contrasts. A water tribunal under Article 262 adjudicates and its decision binds. The Interstate Council under Article 263 only advises.
Binds versus advises.
Number 3, keep your categories rigid. Articles 261, 262, 263, and the trade rules from 301 to 307 are constitutional devices. The zonal councils from 1956 and 1971 are statutory bodies, born from acts of Parliament.
But as you review these concepts, I want to leave you with a thought that requires you to think beyond the textbook. We discussed Article 307.
The unused trade authority.
Right. The framers deliberately wrote a provision allowing Parliament to create a powerful, dedicated authority to act as a permanent referee for interstate trade and commerce. They gave the government the exact blueprint to build a massive trade bureaucracy. Yet, for over 70 years, Parliament has chosen not to create it.
It's wild to think about.
Why do you think that is? What does the deliberate absence of this trade authority say about how Indian political leadership prefers to manage economic friction? Do they prefer the messy flexibility of politics over the rigid control of a permanent bureaucracy?
It is a phenomenal question. Sometimes when you are studying invisible machinery, the parts the engineers deliberately chose not to build are just as revealing as the parts they did. Keep dissecting these foundational concepts, trust the mechanisms we explored today, and most importantly, go absolutely crush those exams. We will catch you on the next deep dive.